I'm writing now.
Good morning, everybody, and happy Privacy Week. Thank you for joining us today. I'm thrilled to have Tatiana Rice here from the Future of Privacy Forum. She serves as director with FPF's U.S. legislation team and leads FPF's biometrics work stream. So I'm going to turn it over to Tatiana to introduce herself further, and I'm really looking forward to her presentation today.
Great. Thank you, Katie, and thank you everybody who is here attending and generally WATEC. I'm really excited to be here and talk to you all about biometrics in the context, I think, both of technology and law and public policy, because as the conversation around AI continues to grow and heighten and have so many different implications for our society and our world, it's really important to better understand how these technologies work, what are the risks, what are the benefits, and what is the existing regulatory structure around these technologies right now. So, as mentioned, my name is Tatiana Rice. I am the director of US AI legislation at the Future Privacy Forum. So, if you all have not heard of us, the Future Privacy Forum is a nonpartisan independent think tank based here in Washington, D.C. We're really focused on advancing ethical data practices, but working pretty cross-functionally a lot across industry, across civil society, technologists, researchers, in order to find consensus understanding about how these technologies work, again, the risks, the benefits, and what are kind of best practices for handling them and handling data flows. And so we do have a lot of different folks who we want to invite to the table so we have a better understanding about how to think about these things. But we also do have a global office, our global offices. So our headquarters is in Washington, D.C., which is where I am, but we do have folks in Brussels, Singapore, Tel Aviv, folks who cover Latin America and Africa, just so we have genuinely a global view of these issues, and those really do differ based on jurisdiction. So generally today, I will be focusing kind of on three main goals. First is giving a high-level overview of how biometric systems work, including kind of the definitions, the technology processes behind it, and the differences across these different types of systems, because biometric systems is a broad category, actually, that considers a lot of different forms of technology for what can be considered biometric. Then I'll talk a little bit about how these technologies are commonly used, why they're commonly used, what are the kind of risks and benefits, and particularly looking at issues that are coming up more and more, particularly in our work regarding data privacy and algorithmic bias. And then lastly, I'll cover the kind of existing regulatory landscape here in the United States, focusing not only on the data privacy laws and the biometric privacy laws, but also as more AI laws start coming to the table, an overview of those laws and how they might apply to biometric technologies. I'm going to take a quick peek at the chat here. Um, that seems like a question for somebody else. Okay, so agenda, I'm going to start off talking about biometric systems and explanation of biometric identification and verification. So, biometric identification and verification actually goes back a long time, back to when the FBI was kind of first using fingerprinting as a way of identifying people. And generally, if we think about identification through people, how humans identify each other is often through the same ways that we do biometric recognition, such as how somebody's face looks, how their voice has different types of intonations, and the kind of mannerisms that we have. And so the focus oftentimes is on this identity concept, right? So when biometric systems are used, we're trying to figure out, is this person who they claim to be, or is this person somebody that we know, right? So how are these devices telling different people apart? So in general, kind of security um, landscape, there are a lot of different ways that you might go about verifying somebody's identity, right? So there's what you know, which is things like password and passkey, what you have, which would be like a fob, a key card, or a license, or who you are, which is again where the biometric recognition part comes in. So, in terms of how these technologies are used, a lot of times in the commercial use cases is pretty similar to how they're also used in the government aspect as well. And again, it's often around this recognition and figuring out somebody's identity. And we moved over to this system more and more recently just because it is not only oftentimes far more accurate. Of course, we'll get into the details of accuracy and bias, but it is oftentimes far more accurate than the human eye. It is far more reliable. And humans just aren't always the best at doing facial recognition on our own. It's also much quicker to be able to use biometric systems at a higher scale. So, the common modalities that we see for biometric recognition systems include facial recognition, fingerprinting, iris recognition, voice, and we're seeing more and more folks really invest in behavioral biometrics as well, such as how somebody walks, their keystroke, or even eye tracking, because those are also unique to individuals oftentimes and a way to be able to tell if somebody is behaving in the same way that they often do. Oftentimes, this is coupled with other types of biometric modalities in order to figure out things like fraud, for example. So, I'll start first with facial recognition and how these systems work. So, this is one of the most common uses. If any of us have a smartphone nowadays, we have probably used facial recognition. And how it works is that it creates a template of your face. So, it is measuring in different types of vectors things like the distance between your different eyes, the distance from your nose to your chin, the distance from your nose to your cheek. And from that, it creates this facial template that is unique to you. And in terms of different types of systems, will have different levels of sophistication. So things like an Apple iPhone facial recognition system has like 1,000 different vectors to be able to determine if you are the person trying to open your iPhone. Less sophisticated systems might have less vectors that they're using and therefore might be a little bit more susceptible to breach or inaccuracy. The other kind that I'll point out that's pretty common is fingerprint recognition. Similar to facial recognition, it's looking at a lot of different unique aspects and vectors of what is in a fingerprint, such as different types of bifurcation, different types of ridge endings, the delta, and it is really looking at the minutia of how those differ from person to person. So oftentimes when these are used, as I mentioned, it is used as an identity verification technology, oftentimes for accessing different types of facilities, different types of devices, or different types of accounts or systems or databases, right? So you use it on your iPhone, you might use it to access a building, you might use it to even access particular accounts that are determined to be more confidential than others in increasing an amount, as folks might have heard about things like the Madison Square Garden incident that happened last year or 2 years ago, it is starting to be used more and more in retail theft prevention. And there's a lot of questions around privacy around that. And so I do want to differentiate that there are actually two different types of biometric recognition when we're talking about theft prevention. So the first, which is less privacy invasive, is post-incident software. And that means that there is just generally like a CCTV camera or any other type of camera that is being used to record. And then once a incident happens, a theft happens, a particular clip of that video is fed into a facial recognition system just on that particular moment in time when the theft is happening, and then running a facial recognition identification. The alternative to that, that is much more privacy invasive, as we saw in the Madison Square Garden incident, where there was somebody who was determined as they were walking into the arena or stadium that they were identified immediately. And they were seen to be on a kind of quote unquote blacklist and escorted out. And this is ongoing monitoring in the way that they have a detailed database of particular people, and they are continuously monitoring every single person to identify if they are somebody who is on this database of people they might be looking for, or just generally a database that they generally have. So there is a difference between biometric verification and biometric identification. And so verification is going to be, again, more of the less privacy invasive technology because oftentimes this requires some form of consent or understanding that their biometrics are being collected because you're verifying somebody's identity against data that the entity already has, right? So you are determining if somebody is who they claim to be already. So this happens oftentimes in the employment context, for example. If you are using an identification system to be able to enter a certain facility, they will have a list of employees and probably have a photo associated with each of the employees. And you're doing a verification to determine if you are the same person that you're claiming to be. Identification is different because you're comparing one person's biometric template against a whole host of them. So things like the FBI's national fingerprint identification system would be a example of identification because you're not just doing a one-to-one comparison, you're doing what is called a one-to-many comparison. So you're looking at a lot of different people's data and determining where it is most likely that there is a match. So this is just a technological kind of overview of what the difference is, again, between identification and verification. As you can see on the left, verification is really just looking at the stored image versus the facial image template that is happening in live time. And identification is looking across a lot of these different people who are stored in a database. So next, I will take a quick look at the chat just to double check. And yes, definitely, that is definitely an issue in terms of fingerprinting for senior citizens. This is actually a really interesting modality that's been happening lately, and we're seeing more and more of, is because over time, your fingerprint ridges uh, degrade, essentially. You have less of these ridges. It makes it more difficult to be able to read them in the different recognition systems. So that's a really good call out. So the two big risks that we are oftentimes looking at are the privacy and security risks and the risk of bias and inaccuracy when we're talking about biometric recognition systems. But before I get to that, or I'll talk a little bit about how they are so high risk, right? So in a lot of data privacy laws, these are considered sensitive categories of information. And oftentimes in any kind of privacy regime, biometric technologies or biometric data generally is considered extremely high risk. And the first reason is immutability. So, unlike things like financial information or social security numbers, biometric templates oftentimes can't be changed, right? Unless you are undergoing some level of significant facial reconstruction surgery. If that kind of information is compromised, it is really hard for consumers to be able to have recourse if their biometric data is breached. However, as the technology has advanced, this is becoming less and less relevant, and it's actually getting much, much better because certain entities, again, particularly those who are more complex and sophisticated, have a level of advanced proprietary encryption software. So, as I mentioned before, there is that facial template. Those who have proprietary encryption are able to put that into a mathematical string that is proprietary to their system. So even if that information is breached, the bad actor would have to have either the encryption key or somehow be able to figure out how to reverse engineer, which is something that is extremely difficult to do. So despite the fact that it is high risk because of this immutability, there are increasing safeguards against this. Um, the other part that's becoming more and more relevant is deepfakes. And actually, this is really hard because deepfakes at this point, because the technology has advanced so much, are much easier to do just with a simple photo. But if you do have biometric data, again, the more granular biometric data that is measuring templates and vectors, it is much easier to create a um, deepfake of somebody that can trick software into providing access to an account or providing access to a building. And so, of course, that increases significantly a level of identity theft, but also just generally fraud and security concerns for certain organizations. And it's been interesting to watch actually over time as we're seeing a little bit of an arms race right now between the creation of deepfake technology and deepfake detection technology, oftentimes both of them using biometrics to be able to combat each other, right? So they're trying to use better liveness detection for biometric systems and having people move so they can tell if something is a deep fake or not. The last thing that is kind of true over time, regardless of how technology advances, is the question of surveillance. And so identification systems that are used to surveil society or specific individuals can cause a chilling effect on speech and activity of individuals. If people feel like they are being constantly watched, they're going to be less likely to engage in things like protest or things that might be adverse to the government and things that are essential for our civil rights and civil liberties. So, as I mentioned, the other kind of risk that we talk about and focus a lot on is bias. And bias comes down to the level of accuracy across different types of demographics. So, biometric systems generally, if you're testing them and looking at them, they can fail in multiple different ways: blurry light or low lighting, blurry iris in photos, smudged print. And when you're doing things to test these systems, you're oftentimes looking at two types of algorithm errors. And again, this is specific to biometrics, but it does also apply in the general AI context as well. So if we're looking in the biometric context of doing matching, a true match, of course, is if I say I'm Tatiana Rice and the recognition system says, yes, there's a 99% rate or percent chance that this is Tatiana Rice. That is, of course, a true match. The adverse of that is if somebody is claiming to be Tatiana Rice and they identify that it's not Tatiana Rice and they are not Tatiana Rice, that also would be a true non-match. So that would mean that the system is accurate if that is the way that it works. The converse of that is if a system is saying that, or if I am Tatiana Rice and it is not showing a match for me, or if somebody else is somebody else and it is showing a match and they are not the person that they say that they are, then of course that is a false match. So you're seeing a level of accuracy in how the algorithm is performing across matches and non-matches. In the more high-level AI systems, and when we're thinking about predictability systems, again, this is equally applicable because you are oftentimes looking at false positives and false negatives. Is this a kind of correct prediction? Is this a correct object detection if you're talking about broader computer vision systems, things of that nature? Oftentimes, this idea of algorithm errors is equally applicable. So in 2019, the National Institute of Standards and Technology really identified this issue across what they call demographic differentials. So that is things like race, gender, skin tone, and the kind of facial recognition vendor testing that they were doing is when different entities are submitting their algorithms for testing to NIST to see how they're performing. And in 2019, they really found a large amount of algorithms did not test very well across different demographics, where false positive rates were varying between factors of 10 to 100 across different types of demographic differentials, oftentimes looking at things like skin color and gender. So this is an example of kind of what testing might look like across different demographic differentials. We're looking at things like performance and error rates. So going back to what I said about the false positives and false negatives, of course, things that are a error rate is going to be those red boxes that we saw. Those were errors. Performance is going to be obviously tied to when it is accurate. And so you see really significantly, this is just an example of one algorithmic system. Um, if you're comparing these different ratios between Asian people and white people, there was a different ratio by 6 factors. You see that across different types of black to white, Asian to white, and female to male. So why does this really happen? Of course, a lot of people here are technologists, so you're going to be able to explain it far better than I do. But a lot of times there is kind of 4 different types of ways that we look at this and how bias can arise. And the most notable one, and one that most folks know, is the lack of representative training data, the idea of garbage in, garbage out. So when an AI system is being trained on a vast amount of data, if it's only trained on data that is not representative of the population, then it is not going to be performing well against the populations who are not in that original training data set. So Even at a different level, if we're talking about things like facial recognition systems that are only performed on white males, of course, it is not going to be as accurate and therefore have a level of bias across skin tone and gender because the training data was not representative of how the system is being used on the user population or the consumer population. There also is just general issues of how the system is being designed, and that can be due to a lot of different factors. That can be due to the fact that if you don't have diverse people who are creating these systems, they might be not thinking of that immediately when they are creating the system or designing the kind of logic that's behind how these algorithms are functioning. There also is just biased applications sometimes. So in a minute or later on in the presentation, I'll talk about this case that the Federal Trade Commission did against Rite Aid when they were using a facial recognition system. A lot of reasons why that system was poorly executed. But one of the things that really contributed to why that system was extremely discriminatory, according to the FTC, is because it was only being deployed in areas where there were high marginalized communities and high communities of color. And so the system was already biased, and then it was being specifically targeted in these areas where there was really high population of people who were not included in the original training data. And therefore, because the facial recognition system was used in a way that informed decision making, it had really significant consequences and really significant reasons as to why even just the application was really difficult for them to be able to come back and show any kind of level of accuracy and or non-bias. The thing to note specifically about facial recognition, though, because it has been gaining more media attention, is that it has actually increased significantly since 2019. Actually, we're at a point today where a lot of the facial recognition algorithms, particularly ones who are submitted for the NIST facial recognition vendor test, are extremely accurate across different demographic differentials. And so, again, this is highly dependent on the ones that are getting submitted. So that means if a system is not being submitted, then you just might not know. It doesn't mean that all facial recognition systems are accurate, but it means of the ones who are submitting their algorithms to NIST, they're showing a high level of accuracy across these different demographic differentials. And again, when you do have a biased systems, these harms can often be concentrated on marginalized groups, particularly if you're using them in these high risk contexts where we're talking about people's impact on their lives, then their livelihoods, such as in the law enforcement and immigration enforcement aspect, when you're doing things like fraud detection, what is called landlord tech, which is essentially biometric recognition to be able to access a building or a residential building, and then access to benefits, access to finances, any kind of system that is being used where somebody needs to have access to that thing. And it could be even a part of their existing civil rights, which I will talk about when we start talking about AI regulatory approaches. So, with all of these risks and a lot of these different types of different implications, why do folks even use biometrics at all? So, as I mentioned earlier, biometric recognition systems are oftentimes far more accurate and scalable than the human eye. And it is, as I also mentioned, one of the strongest methods of security for governments, consumers, and businesses, particularly when it's being paired with multi-factor authentication. Most folks probably have seen that multi-factor authentication has really picked up steam and is really integrated in most products nowadays and most services. So that means that you're using not only a username and password, but you might also be using biometrics as well. It is also being used more in fraud detection as well. As I mentioned a little bit before, behavioral biometrics are starting to be used more. So if we're looking at something like if you're accessing your financial information on your phone and you're even holding your phone in different types of ways, they are starting to track that. And there are obviously privacy questions about tracking the user's behaviors, but they can be used to figure out if this might be somebody different than the original account holder who usually accesses this just based on how somebody is interacting with their phone or the different types of angles that they're holding their phone at. Um, Otherwise, pretty common areas of just it's generally convenient. It's much easier to do facial recognition to access your phone. And it is oftentimes required by law for things like background checks. People often do oftentimes do have to do fingerprinting check, or if you're trying to adhere to what are called kind of reasonable security standards, which are looked at by industry standards. Industry standards oftentimes do favor biometric recognition over other forms, especially if it's just by itself. So I'm going to chat a little bit about regulatory approaches, and this will take me a little bit of time because there's a lot to talk about. And then we'll do a couple takeaways and open it up for some questions. So in regulatory approaches, we can even go down farther into four different types of categories. First and most direct is biometric data privacy laws. Second is BIPA litigation. So that is litigation and enforcement that happens under the Illinois Biometric Information Privacy Act, which has a private right of action for consumers. Third is comprehensive data privacy laws. And fourth, I will start talking about AI regulations. And AI regulations are my bread and butter, I will say. I did previously have a lot of experience in biometrics. As I've been trying to now incorporate everything, folks are welcome to ask me questions more about AI regulations as well, because I've seen a couple of questions in the chat on that. So, biometric data privacy laws are focusing specifically on biometric information or biometric data, as compared to comprehensive privacy laws that look at a range of different types of personal information. So, comprehensive, maybe focusing on things like name, health, address, location. They're covering all these different types of data. But biometric data privacy laws obviously just looking at biometric information, particularly in the context of identification. And that identification component is actually really important and something that is oftentimes really litigated because there are questions that are really muddy about how easy it is to just identify somebody from a photo. Should we be considering that biometric information, or should we be considering that at the same level or threshold or risk because it does end up sometimes having the same consequences? In Washington, you do have a biometric data privacy law. So, of course, I was going to include those definitions. But what is interesting about the Washington biometrics law is that you categorize by biometric identifier, which is found in the other biometric data privacy laws in Illinois and in Texas. But you also have a definition of biometric system. So you're talking at the system level of when those are being used to capture, process, and store biometric identifiers. The Washington biometric law has not been enforced as far as I've seen. So there are some questions about how this law is interpreted and applied. But it obviously still is on the law, it is on the books. So there are a number of different types of requirements that companies need to adhere to be able to use biometric recognition systems in the state. Oftentimes, these actually look really similar across the different states that do have biometric privacy laws. So having some form of notice and consent, a prohibition against selling and sharing biometric data, having some level of reasonable security. So back when I was talking about the different forms of encryption, oftentimes that is what they're talking about, is having some level of encryption that makes it really difficult to breach that biometric data. And the last one is having a retention schedule, right? So you don't want to have people storing biometric templates and biometric information indefinitely, particularly because the longer that you store them, of course, is going to create a larger and longer security risk, not only for the individual, but for the company. So wanting to be sure that there is some level of time or purpose tied to that that says when you should be able to get rid of it. And there is an exemption in the Washington law if that collection, use, or storage is needed for a security purpose. So that's a pretty broad exemption, but it is really important, again, going back to the context of biometrics being a increasingly noted way of doing security and having that system being able to be used, whether that is in access to stores or access to devices, etc. Again, because it hasn't yet really been litigated, it's hard to really know what the breadth of security purpose is. But hopefully we'll be able to see at some point. So, in terms of what these requirements say, it is first and foremost that affirmative consent is a must. And that means that an individual has to not only consent to their biometric information being collected and used, but they have to affirmatively do that, right? It can't just be in a privacy notice because most people don't actually read privacy notices or privacy policies generally. That kind of implicit consent, as some folks might consider, is not considered to be affirmative consent. A person has to know specifically that their biometric data is being collected, um, potentially even why their biometric data is being collected, and say, yes, that is okay with me. And as I mentioned, there are some exemptions to this, depends on the law. Washington does has have these exemptions. And I'm going to take a quick look at the chat to see if I can answer anything live. Yes, vein pattern recognition is actually a really growing field. I did some research on it last year, and it is starting to become more, I wouldn't say used because I don't think it's used much commercially at least, but it is certainly being recognized and researched in more of the academic spaces as being a way to identify people. Um, Eyes that change color, develop cataracts is another way that biometric systems might be faulty, so definitely a good catch. FERPA states that written signatures are considered biometric data. I did not know that. That is very interesting. Are they to be included as biometric data in our assessments? That's a really good question. I would need to relook at the Washington Act. A lot of times in these privacy laws, there's exemptions for compliance with other laws, and they will state what those other laws are. I believe in Illinois it does say FERPA is included in that, but I'm not so sure about Washington, so we would have to check. But I would recommend just taking a look at the Washington law and saying if there are an exemption for compliance with other laws. There's been a lot of news concerning racial bias and facial recognition. Yes, absolutely. Definitely happy to talk about all of that. I see a lively discussion in there. Um, can content be removed after the fact? For example, requesting Rite Aid to remove it. Yes, that is something that can be done. Um, it depends on where you are. So if you're in um, California, for example, you do have the right to request that information be deleted. I don't think that that's in the, it might be in the Washington Act. I need to recheck it. But again, it's very jurisdiction specific on who has rights to be able to do that. Maybe some companies will just do it no matter what, but a lot of times it's a little bit wishy-washy, and it will depend on whether you have a right as a consumer to be able to request it. Um, and that's because that biometric template is oftentimes stored, and sometimes it might be needed, right? So if you're an employee and your employer requires the use of biometrics in order to access the building or access devices, you're likely not going to be able to exercise any kind of right to delete that data if it is necessary for them to be able to protect their building or protect their device or account. Um, in the EU, people have been compensated for using their data. That's really interesting. I've not heard that before. Interesting regarding collection. Would you say the use on concerning collection and use of biometric information technology often stem from misrepresentations about data collection practices, failure to provide notice, or lack of consent? I'll say kind of all of the above. Um, yeah, I think something that is happening in data privacy circles, and I apologize for taking a little bit of a divergence here, but I do think it's an important part to discuss, is that in data privacy, we've been focused on something that is called the notice and consent regime, which is what you're kind of seeing here on the screen regarding affirmative consent. You have to notify a consumer that you're collecting this data, and they have to consent to that use. There's been a lot of criticism by regulators, by academics, by researchers, by civil society that this is ineffective and a not perfect way to actually be able to protect any kind of data, because it is not incentivizing the company to take certain actions, such as limiting the amount of data that they're collecting, um, as opposed to putting a lot more burden and obligations on consumers, on employers, when there could be, and oftentimes is, an information asymmetry regarding most people don't actually know that data is being collected. Most people don't read these privacy policies that say the data that is being collected. Again, with biometric privacy laws in the three states, there are specific requirements that it has to be extremely explicit and affirmative. But in a lot of other places, you can just include it in a privacy notice. So consumers are not aware, and oftentimes it's just hard to understand because there's a lot of legalese and privacy policies. So folks are trying to push towards away from the notice and consent regime into something that is more affirmative business obligations. And so we're actually seeing this in the data privacy laws that are getting passed more recently, that there is still some notice and consent regime because that is still fundamentally important for people who can understand and exercise their rights, but including more strict prohibitions or limitations on the business practices of how those are being used and when you can collect the data. Does it need to be tied to a specific purpose, and should you have to delete it after that purpose has been fulfilled? Um, Again, reasonable security. This I'm going back to the requirements under biometric data privacy laws. I'm going to move through a little bit quickly because I want to make sure I get to the AI regulation portion. Um, but as I mentioned, data minimization is an increasingly large focus of data privacy as we start focusing more on the business obligations that I was just mentioning. So oftentimes, businesses that are regulated under these laws should be only storing the data as long as reasonably necessary for that processing purpose. So again, going back to the example of biometrics being used for a security purpose, that means if an employee leaves, that data should be deleted immediately once that employee leaves and they no longer need access to the building. The Illinois Biometric Information Privacy Act, which has a private right of action, requires it minimally after 3 years. So even if an employee is, for example, at a company for 10 years, the company would need to refresh that consent after 3 years, even though the processing purpose hasn't actually been fulfilled yet. So I'll talk quickly about BIPA litigation. As I mentioned, the Illinois Biometric Information Privacy Act has a private right of action, and that private right of action actually doesn't require any type of injury for consumers to be able to allege claims in court. So they can largely say, hey, you collected this data without my consent, I'm going to sue. And this has been a huge issue in Illinois, and you can really see it from both sides. On one hand, it really has incentivized and fundamentally changed how businesses think about collecting and managing biometric data, just because there has been thousands and thousands and thousands of lawsuits in Illinois. And on the converse of side, that is really difficult not only for the businesses to be handling, but the courts as well. And so there is a little bit of this trade-off regarding, okay, should we use biometrics? How are we using them? And what do we think is the term for collection? What is processing? Really having to get down into the granular details of what does consent look like? If your car is collecting biometric information, because sometimes cars now are doing biometric recognition to be able to determine which driver is at the wheel, what does consent look like? Does it have to be on that screen? Can it be written? What does that look like? And those are questions that are starting to be determined and questioned by the courts. So, as I mentioned, there's been over 2,000 class action lawsuits in Illinois. There's been heavy incentives for businesses to settle before trial. And there was the first jury trial award happened 2 years ago, actually, and it was for $428 million. And that's because oftentimes these actions are happening as class actions, which means that there are multiple people, perhaps dozens, maybe even 100 different types of plaintiffs who are in those. And there is a 5 year statute of limitations. And there was recently, 2 years ago, a case against White Castle against use of a biometric system without employee consent initially, with all of these different employees using it. And the court ultimately found that every time that their biometrics were scanned in their biometric recognition system, that was a separate violation of the law. So at large, White Castle was facing what could have been a multi-billion-dollar judgment that could have made them go bankrupt. Um, the legislature last year actually did amend the law so that that is not how you read it or interpret the law anymore. But nonetheless, these are very large settlements that obviously really incentivize companies to have to do the right thing or face these really large judgments. These are some key issue areas that are happening in BIPA litigation. I mentioned some of them, but I do want to move forward just so I can cover some of the AI regulations, but happy to talk about any of them. These are talking more about the comprehensive data privacy laws, some of the other approaches that we've seen in other states. For example, New York is a good example. New York City has a law regarding biometric data collection specifically for retailers and commercial entities that are like selling goods. So it's not quite as broad as Washington's, but it is specific to their retailers. Um, Portland, Oregon passed a ban on facial recognition for all public and private entities. This is actually a really big deal and something that we/I had not seen before. And since then, 17 other municipalities have similarly banned government use of facial recognition. At the same time, last year, as we were trying to kind of follow these developments, some of them started getting rolled back. So a little bit time of flux, particularly in our year of 2025, of where those facial recognition bans are. So let's talk about AI regulations. At a high level, it is really important to know that the advent and use of artificial intelligence, one, is not new. Artificial intelligence or the development of it has really been happening since the late 60s. However, the increasing accessibility of it to people and the complexity and capabilities of it are new and are areas that lawmakers, regulators, and people are trying to grapple with. And what are kind of novel risks, and where does there need to be guardrails? So one thing that we always say is that existing law already applies to these technologies. And that's because if you're using these technologies in ways that are already covered by the law, they do already apply, right? So if you're using an AI system regarding housing, employment, consumer finance, credit, the law still applies no matter if a human is making the decision or an AI is making the decision. However, there are some gaps in that lawmakers are trying to address. Hence why the Colorado AI Act was passed last year, and other kinds of legislation looking at what they call high risk AI. And they categorize this as AI systems that are used in these high risk contexts that implicate people's lives. And that includes areas oftentimes that are already protected by existing civil rights laws. And the reason for that is, as I mentioned, the gaps in the existing law. These laws were applied or created back in the 60s. The idea of the internet, the digital ecosystem, was not something that was even in consideration when those laws were drafted. So questions about how do you measure bias? How do you mitigate it? What are the different types of steps you have to be taking as an entity? And how does the state view what you should be doing to mitigate these risks? All are open questions that the courts have not been able to catch up with the technology on. So laws like the Colorado AI Act did get enacted, and other types of legislation that is now becoming more prevalent. The FTC has also started doing much more enforcement on this. Again, unclear as to what that looks like moving forward in a Trump administration. However, that is something that they had start building on for the past, I would say, 3 to 4 years. And then, of course, there's the EU AI Act, which I'm sure a lot of people have heard of. This really broad risk-based approach to AI regulation that categorizes different forms of risk. There have unacceptable risk, which is essentially a prohibition on certain types of AI uses unless it is for some kind of permissible purpose or fits into some exemption. And one thing to note about that for biometrics specifically is that if you're using biometrics in public spaces for identification, that's an unacceptable risk under the EU AI Act, and therefore it is kind of prohibited. However, there's a lot of nuances in that where I am not an EU lawyer, so I'm not going to get into that, but it is something to note as an approach that is being utilized in the European Union. So, as I mentioned, again, a large goal of these laws is to mitigate the risk of algorithmic discrimination. Because this evidence of discrimination occurring due to AI biases and inaccuracies is extremely well documented and prevalent. Because, as I mentioned, every type of AI system, every type of machine learning system is trained on data. And if that data is not representative, you are not going to have an accurate system across these different types of demographics and protected classes. And so when you're using it in these high risk contexts like employment, insurance, housing, education, there are actual individual harms, but also collective and social harms as well, which is something that we had actually done this chart. I want to say back in 2016 when these started really to come up and was getting studied more and more. So, a little bit about legal discrimination and how it applies to AI. I'm not a civil rights lawyer, so I'm just giving you kind of the TLDR here, but we'll use employment as an example. So you are prohibited from using tests or selection methods regarding who you employ or promote that cause what is called disparate impact. And that means that if you are selecting a particular group, far less likely than your most selected group, then that might be a disparate impact. And that might be unfairly disadvantaging people. And oftentimes, when you're thinking about, okay, how do you tell if something is crossing the line of bias, right? So AI systems oftentimes always have bias. It is a mathematical phenomenon. It's not always concerning, but when does it hit that rate of discrimination? And under the EEOC guidance, that is what is called the four-fifths rule, which is if the selection rate for a protected group is less than 80%, of the selection rate for a different group with the highest selection rate, it could indicate adverse impact. And that in itself is not enough for somebody to be able to sue. Oftentimes, there's another step to it, which means that the business or entity has to show that there is a legitimate business reason for having this disparate impact, whether that is it is a necessity of the job that somebody has to be able to like move on their feet as opposed to kind of accessibility concerns. That might be a legitimate business reason why they are needing to have a level of disparate impact against people who are differently abled. So, as I mentioned before, there's a lot of different reasons why state lawmakers look to regulate. Last year, we were tracking this really, really closely. I unfortunately did not sleep a ton last year because there was something like 400, 500 different types of AI bills out there. And a number of them did pass. So, I'll talk about that in a second. But there's a lot of different reasons why people were looking to regulate. Of course, ensuring fairness and preventing discrimination was one of them, but also just generally enhancing transparency and accountability and protecting privacy and data security were two of the other really key concerns at what lawmakers were looking at and what were kind of concrete risks of harm that they could demonstrate and show to other lawmakers and people who are trying to pass laws that this is legitimately an issue and we should be able to incentivize the market to have these kind of ethical practices. So I'm going to talk specifically on the Colorado AI Act because I do think it is kind of the most significant piece of AI legislation that happened last year. It also is getting copied in other states now as we are in a new legislative session. And what that focuses on is regulating developers and deployers of high-risk AI systems. So as I mentioned before, these high-risk AI systems are oftentimes focused in areas where there's existing civil rights law. So a consequential it's when these AI systems are being used in what they call consequential decisions, which means that it has some kind of, when the AI system has an output that is being used in a way that has an effect on the provision or denial of education, employment, financial and lending services, essential government services, healthcare, housing, then they're covered under this act. But if you're using AI in a way that is outside of these contexts, or if you're using AI in a way that actually doesn't really impact the provision or denial, meaning if a consumer does or does not get this, then that also is not in scope. An example of that might be, for example, somebody actually might consider an Excel spreadsheet an AI system just because there's a level of automation and logic rules behind it. However, if you're using an Excel spreadsheet, it's going to be unlikely that the use of that is actually leading to the provision or denial of somebody's rights to education, employment, financial and lending services. And they take an interesting approach in this in that they impose what is called a duty of care, which means that developers and deployers have to use reasonable care to protect consumers from reasonably foreseeable risks of algorithmic discrimination. And they differentiate between these different parties for really significant reasons. Developers are the folks who are developing the product or the AI system or the model. And those are the people who are doing the training data, who are determining what they think might be the purpose of it, or it could be a general purpose model. And they are doing the oftentimes selling to a customer or a deployer. And the deployer is the entity who is interacting with the consumer, who is using the product in a way that might be impacting consumers. And because of their different positioning, they have different responsibilities. So Hush Blackwell, based out of Colorado, actually did this really good Venn diagram of what those obligations look like. If you see on the left, developers have far less obligations just because of the nature of their role is largely focused again on ensuring that deployers have all the information that they need to ensure that they're using the product in the right way and in a kind of ethical way. But both parties have these duties of care, have to notify the Attorney General regarding any kind of identified instances of algorithmic discrimination. And they both have to have some level of public disclosures, which means developers have to have something on their website that says, we developed HR software, which could be considered high risk because folks are using it in the employment context. That would be an example of a public disclosure, where deployers might be doing the same kind of public disclosure and saying, we use AI software in order to rank candidates, for example, if that's the way that they're using it in an employment process. The other thing I want to mention really quickly is the other approach to this is looking at generative AI as a particular technology. So the Colorado AI Act and the high risk AI approach is focusing on particular uses of technology. So it's focusing on the uses of AI in these really high risk contexts. The alternative approach to this, which we saw a lot in California this year, is focusing on the specific risks associated with generative AI. So Utah passed a law basically saying if you are using a generative AI system to interact with a consumer in different types of areas that are already protected under their existing licensing regime, under their UDAP authority, then you have to tell those consumers that they're interacting with a generative AI system and they're not interacting with a human. Um, California went a step further beyond that with two of the laws that they passed. So AB 2013 requires that developers of generative AI systems have to publicly disclose documentation about the data used to train these systems. So this is far more granular information and might look closer to a privacy notice or any kind of privacy disclosure about the kind of data that's being used to train these systems. And the reasoning behind that is not only concerns regarding data privacy and data sets generally that might be seen or shown to have bias, um, but also copyright is the other area, which I don't focus on, but of course is an area of concern for a lot of people that copyrighted data is being used to train these systems. And there is a crossover here, particularly for biometric data, because generative AI systems, particularly those who can output visuals, um, are oftentimes relying on photos to be able to train the system. So a system understands what a cow looks like, what a moose looks like, what a cat looks like. But it also might be trained on photos of people, for example. It might be trained on photos of different presidents. It might be on just generally social media profiles. So they can see so the system can learn what a human looks like or what a person from let's say Canada looks like or a person from Mexico looks like, for example. And so there is a crossover regarding whether that photo and that visual information to train that system might be considered biometric data under existing law. And the other law that was passed in California was SB 942. This is more of a requirement for if you are a generative AI provider, you have to have an AI detection tool that allows individuals to check whether content was created or modified by an AI system. So I'll really quickly go through this and then I'll stop for questions. The FTC has used some of its consumer protection authority to enforce against kind of unfair, deceptive uses of AI. I mentioned this earlier on. Rite Aid had used a facial recognition system in a way that caused discrimination and bias in their stores. It was something that they had purchased from a vendor, and the FTC had found that this was an unfair trade practice because they failed to do a lot of things that are kind of common in AI governance, including assessing the accuracy of the system, monitoring the system for its performance, using low quality images when it was doing more data test or more data training, and really just employee inadequate training about how the system worked and how they were supposed to use it. Um, so general takeaways. First is just generally that biometric technologies, as I said at the beginning, range widely in purpose and risk profile. So, as I mentioned, one-to-one verification has a little bit of a different privacy risk than, for example, one-to-many. All systems pose these different types of risks and bias and discrimination across different types of algorithmic systems based on what they are trained on. Um, Most biometric data privacy laws are fairly consistent, really focusing on the use of biometrics for identification, focusing on the need for consent and data minimization and retention and deletion, and that a lot of BIPA litigation coming out of Illinois is incentivizing more companies to adhere really closely to biometric compliance. And then lastly, is that AI regulations, which continue to come up and will continue to happen this year, focus on issues like bias, transparency, and consumer protections, do apply to biometrics in particular contexts, but particularly in high-risk scenarios against individuals. So that might be including using people's public social media profiles, as I mentioned, to be able to train a biometric recognition system. That is something that is not only going to be covered under a biometric data privacy law, but is starting to be covered under these AI laws. And so different steps that are pretty common are having some level of transparency, having internal AI governance, which means policies and personnel kind of in control of these things, doing risk assessments, having employee training and oversight about how these technologies work, what are their limitations, how should they be used, how should they not be used, and having some level of due diligence with vendors, knowing what you need to be asking them how they're testing their products, how they were trained, etc., will really help a lot of folks who are working with vendors to use AI systems with consumers or users, have better management and understanding of any kind of risks that might be available in the system. So with that, I have talked a really long time, very quickly. I'm happy to open up for questions for the remaining few minutes.
Thank you so much, Tatiana. That was such a fantastic presentation and so in depth on a lot of complex areas that we talk about frequently in technology and in the state of Washington. So appreciate the view from your perspective across the United States and Europe, and also bringing it back home to Washington. So we are out of time, but if you can stay for a couple minutes, so I understand if people need to drop. Go ahead, but we can, if there's a few questions. I think there was a question about, one of the questions was about whether the duties apply to both employee and the company. I'm not sure what that was in reference to, but I having to do with some of the AI pieces, I think.
Yeah, I think that's referencing the Colorado AI Act and kind of those high risk regulations. So, yes, the duty of care to mitigate any kind of risk of harm for algorithmic discrimination is on both deployers and on developers. And given that does apply in the employment context, would also apply to employers.
Okay, fantastic. And then there was a question. It says IBM has been accused of using Flickr image site without full consent of people in the images. These are under a Creative Commons license. Are you aware of platforms that allow you to easily opt out of the use of images? I think is what they're referring to.
Yeah, really good question and example. So with that particular platform, I don't know. I know because Clearview AI is another very large facial recognition company that has gotten sued and issued into a large settlement. there is a right for anybody in the United States to be able to opt out of their facial recognition database if they like. All you really have to do is look up Clearview settlement, I think, and you should be able to find the information that you need. For everything else that's outside of that, unfortunately, it's going to be extremely jurisdiction specific as to whether you have that right to be able to opt out.
Fantastic. Well, I think we're out of time for today, but thank you so much for joining us and for sharing all of this fantastic information and your expertise and recognizing Data Privacy Week. So thank you.
Happy Data Privacy Week, everybody.